Why are the Democrats defending Fauci? The 6-foot rule, Mr. Producer? He doesn't even know why there was a 6-foot rule. That's what he testified today. I mean, I can remember all the floors, stand here, stand there, social distancing. We coined the phrase socialist distancing, and that's what it turned out to be. He, denied everything he had anything to do with. But we'll get to that a little later. Hunter Biden's trial has begun in Wilmington, Delaware. I'm surprised they didn't move it to Rehoboth, Mr. Producer. Or move it to the Lincoln Room at the White House so they could actually have a slam dunk jury. But nonetheless, this is a slam dunk case. And yes, people who lie on federal forms under penalty of perjury are prosecuted. I heard a prosecutor, good guy, say that he never brought cases like that. Well, I'm sorry to hear that. I'm sorry to hear that. You sign a tax form, a gun form, all these forms the government wants you to sign. And if somebody signs it and they're lying under penalty of perjury, you don't charge them? People get charged for a hell of a lot less than that. I also like the moral equivalence again. We had the moral equivalence that the life-loving democracy, the Jewish state in Israel, is akin to the monstrous, bloodthirsty butchers of Hamas. Now we have Donald Trump, convicted felon. They violated his due process rights, his equal protection rights, and everything in between. But now Hunter Biden's on trial in Wilmington, Delaware. And this judge in a federal court is not going to deny him his due process rights. He knows exactly what he's charged with. Exactly. The jury instructions will be clear when the time comes. Everything will be copacetic like a real republic with a real court system. They're not the same. Not even close. And this is what I want to talk about briefly here. I've been spending every day and every evening on radio, on TV, on the internet, explaining why there must be an effort made to try and bring this case to the U.S. Supreme Court. Whether it takes it or not, we don't know. If we take it there and they say no, so be it. And the whole nation will have to live with the consequences of that. But I've rejected the position of many of the television lawyers who said, really, there's no way to do it. It might happen, but it might not happen. It's a difficult battle. It's an uphill fight. I've never heard of anything like this. Yes, it's tough. It may not work. But I know it won't work 100% if you don't try. You need to give the Supreme Court the opportunity. It can't act on its own. Particularly when you consider, as I explained over the weekend, and I want to put a fine point on it here, that what's happened in this case in New York, before it's forgotten, and we move on to the next issue, but I forget nothing. It's the greatest assault on our Constitution, the greatest assault on our Union since South Carolina was the first state to secede. New York is the new South Carolina. New York is the home of the new Confederacy. Same party. I'm not talking about slavery and race. I'm talking about the war on the Constitution. You see, the Civil War was a war about slavery. It was a war about the Union, and it was a war over the Constitution. It was a war between the Republican Party and the Democrat Party, as it is today. And it's a war over the Constitution. All the talk, and on Fox the talk was correct, all the talk by the former federal prosecutors, by the defense lawyers, by the legal this and the legal that, fill in the blank, most of them were right. And you can go down a whole list of due process violations. And you can see the anguish, you can hear the passion here and there. People saying, I've never seen anything like this. In my 35 years, it's my year as a prosecutor, federal prosecutor, my years as a DA and a judge, my years as a defense lawyer, my years as a professor. They're correct. But then they throw their hands in the air, and that's the end of it. Well, that's where I pick it up. That's where I pick it up. Because I have battled these bastards for 40 years. That is the hard left and their tactics in the courtrooms. You can't play patty cakes while they're throwing legal Molotov cocktails. And that's the difference between those of us who are in the conservative legal movement and others who have practiced more traditional law. We have fought these people before. We know who they are. We've gone up and down the federal court system, up and down the various state court systems. And so there is the lane with the appellate courts in New York, but that's not satisfactory because the damage has already been done to the entire system. The federal constitutional system, the federal election system, reverse federalism, where a state seizes the authority of the federal government. Even worse, they seize the authority of the federal government to deny due process rights and equal protection under the Fifth Amendment, projected onto the states through the 14th Amendment. That is a federal matter. A serious, grave, immediate federal matter. The father of the Constitution, James Madison, in the 1830s, as he could see the storm clouds forming for a possible war between states, he wrote about this extensively in a letter to Edward Everett, who, by the way, was the man who gave the speech at Gettysburg that went on for over 2 hours before Lincoln gave his speech. It was 56 words long. Nobody remembers Everett's speech. Everybody remembers the Gettysburg Address. But he asked questions, important questions to Everett, to James Madison, and James Madison took the time to write a multi-page letter. They didn't have a computer and a typewriter. He handwrote his letter. And the father of the Constitution said some very, very profound things. Number one, you're not just a citizen of a state. When the Constitution was adopted by these states, you became a citizen of the United States. You have protections in the state, and you have protections as a citizen of the United States. And if a state on its own seeks to deny a citizen the protections of the federal Constitution as a national citizen in the United States, that's unacceptable. That's number one. Number two, states began nullifying federal law. We're talking about the southern states, the slave states in particular. They said, we have every right to do this. The Constitution doesn't say we can't, and so we will. James Madison said no. Remember, he was from Virginia. He said, no, that's not right. Once you join this constitutional compact, unless you didn't mean it, you're part of the United States. And so you have state sovereignty, areas traditionally that belong to the state. And then we've created this new federal government that also has sovereignty over certain areas. And the Constitution does its best to determine what's what, even though it's not perfect. But you don't have the power to nullify a federal law because your state disagrees with it. Now, you have the power to bring a lawsuit. in the federal courts. And by the way, often the states win when they do. When you have a conflict of laws or constitutional conflicts or a conflict of interpretation, of course. But you don't have a right just to unilaterally nullify the law. We no longer have a United States, and you will have succeeded as a state or multiple states in destroying the compact that you committed yourselves to. And number three, I would add, we have a Bill of Rights. The Bill of Rights was adopted after the ratification of the Constitution. The Bill of Rights were ratified by the states as well. And over the years, I've read and studied these various state convention debates that took place. There have been excellent books written about it. There are transcripts of some of them. And I would look very carefully at 7 of them. Most of the Bill of Rights resulted from states telling what would be the new Congress, we will ratify this Constitution, but there are changes or additions that we insist on. Because those men who drafted the Constitution and adopted it in Philadelphia, they didn't want to open up the whole Pandora's box and all of a sudden have 5,000 things and criticisms and so forth. And so they said, look, please ratify the Constitution and we will revisit these issues. And so the Congress met under the Constitution. And for a while, they were ignoring what they had promised the states, except when the father of the Constitution, a representative from Virginia at the time, James Madison, stood up and said, we made a promise to these states and we have to keep it. As a footnote, James Madison was elected to the House of Representatives by defeating somebody you may have heard of as well, James Monroe. They both lived in the same county. Monroe would become president later, of course. He was not involved directly in the declaration of the Constitution, just a little bit historical fact. Madison proposed to the new Speaker of the House, look, we ought to have a committee of the whole. The whole House of Representatives should do this, put together a package. But they decided to set up a special committee with Madison as the chairman. They came up with 17 amendments based largely on what the states had raised. The states were very, very concerned that this new big government would not protect the individual. There'd been a big debate, at the Constitutional Convention over whether there should be, they didn't call it a Bill of Rights, but an enumeration of rights that belong to the individual. And the person who pushed this the hardest, you may have heard of him, it was George Mason. And one of the people who opposed it was James Madison. Madison said, if we start listing them, what if we miss something? And Mason said, well, if we don't list at least those that we believe are core, then we're not emphasizing them. Turns out Mason was right. Turns out Madison knew it. And so those amendments proposed were sent to the Senate. They whittled it down to 12. The House adopted the 12, 2/3 vote of both houses. It was sent to the states.